Hello guys, today we are looking into Insolvency and Bankruptcy Code 2016. Let's say company A is a debtor, company B is a creditor. That means company A has to pay to B. Let's say company A is not paying the amount in a time specified. How can creditor recover that amount? It's a huge amount. How to recover? For that purpose, we have IBC 2016. IBC 2016 that will provide recover the amount. Let's say answer one by one. Why IBC 2016? Why? For that answer is to speed up resolution of stressed asset. In the country. So in case of banking we say NPA, not performing asset. So what is the NPA? We are not able to, bank is not able to recover the amount which is lended. So in company they need some type of resolution that is provided for recovery of the asset. In my example I given the debtors. So the resolution, the plan is given by the IBC to recover the amount. So that is why it is important. That is why it is came into picture. Next question: who applicable to individuals, partnership firms, limited liability partnership firms, and corporates. This is basically we'll see in detail. So this is applicable. Next comes when. I'm looking into why, who, when, how. That type of questions we are answering before we are moving into subject. When authority to decide insolvency application, within how many days? Yes, within 180 days. As you know, there is a 90 days extension also. I'm talking about the operational creditors. Let's see who are the operational creditor, what is the financial creditors. This is with regard to the operational creditors. So within 180 days resolution plan will be finished. So when there is a one more fast track, correct, fast track process, that is of 90 days available for specified entities. Last question: how? Adjudicating authority, that is NCLT for corporates. National Company Law Tribunal, and the DRT for individuals and firms. Let's say there is a default. We said there are two types: individual and the corporate person. Individual and also partnership firm also will come. So you will file to adjudicating authority in case of any default. For this we'll go to the NCLT in case of a corporate person. Any appeal, it will go to the appellate tribunal, NCLAT. Any more appeal, Supreme Court. In case of individual, it will go to the DRT, then appellate tribunal, then Supreme Court. Okay, how it works? Applications for insolvency process. I will divide into three. First we have financial creditor, then we have operational creditor, let me give third example of corporate debtor. Application for insolvency process. First we will deal with the financial creditor. Filing of application under a financial creditor before adjudicating authority. Next comes furnishing of information. Next, within 14 days adjudicating authority ascertain the default. What do you mean by default? Default not repaying the amount to the creditor. So first one with regard to the financial creditor, filing of application before a adjudicating authority, furnishing required information, then within 14 days of adjudicating authority ascertain the default. So it will pass order adjudicating authority. So there is a two possibility of order: default occurred, default not occurred. You cannot simply put file or application if there is a no default. If there is a no default record, application will be rejected by the NCLT, adjudicating authority. If there is a default, AA, adjudicating authority, will admit the application and it will communication of order to financial creditor within 7 days of admission of application. So it will communicate to the financial creditors. Why financial creditors? Because application by the financial creditors within 7 days of that application, admission of the application. Then insolvency will start process. Commencement of insolvency resolution. Improve how to recover the amount. All this will start. Insolvency resolution process will start. This is with regard to the financial creditor. First, filing of application before AA, furnishing of information within 14 days. AA ascertain the default. They will pass order. If it is occurred, they will admit the application. If it is default is not there, reject the application. Once the admission of the application is done, then communication to the financial creditors within the 7 days of the admission of the application. Then commencement of insolvency resolution process. This is under the financial creditors. Next comes second one, operational creditor. So first, send demand invoice to a corporate debtor on occurrence of default. A sold was to be at worth of rupees 10 million. That is 1 crore. So B is not paying the amount. So what A should do? Not directly going to the adjudicating authority. Demand notice should be sent. Demand of invoice to this person, not directly going to the adjudicating authority. Debtor intimates to operational creditor within 10 days of notice. So how many days given to be in this case? 10 days once the notice comes to him. Next, what happens? So there is a two possibility: existence of disputes or repay the amount, repayment of unpaid operational amount. So this will end here. What about this? There is dispute is there. B is telling the amount is not rupees 100 million. There is a defects in the product. I am not giving the whatever the disputes. So if there is a dispute, if payment or notice of dispute not received within 10 days, then file to adjudicating authority. So within 10 days nothing is received, the notice of dispute, nothing is received, or a payment is not received, then you can go to adjudicating authority. You means operational creditor within 10 days. Then operational creditor proposes for an interim resolution profession. Within 14 days of receipt of adjudicating authority will admit the application or reject application. Within how many days? 14 days. If there is a admission of the application, then commencement of the IRP. So that is the second type. Third, corporate data. On commission of default by corporate data, corporate applicant files, who files? Corporate applicant files application before adjudicating authority. We'll see who are the operational creditor, financial creditor, corporate applicant in later on. Furnishing of information. Then same thing, AA passes order within 14 days, correct? So order, in order it will admit or reject. If it is admit, commencement will start of IRP, insolvency resolution process. Or if there is a reject, there is a chance notice is given to rectify the defects within 7 days. Okay, we'll go to questions directly. We'll understand more clearly for the examination point of view also. RAB Bank Limited, banking company. So there is a banking company. Has defaulted in payment of dues to their catering contractors. Okay, there is a company of catering contractors. Catering, food, those who prepare food and serve food, catering contractors. Who defaulted? Had defaulted in the payment of dues to banking company defaulted. Okay. Can the contractor, as an operational creditor, initiate insolvency process against bank? So they are telling this is the operational creditor. First, you should understand who are the operational creditors. Operation creditors are those who have sold the goods and services and they are expected to receive the amount. So may these operating activities, they did operating activities. So they are expecting from the debtors to receive the amount. Okay, this is a very basic thing. Now your main question is applicability of IBC 2016. That is the question. Can contractor as an operation creditor initiate insolvency process against the bank? That is means, can he go to adjudicating authority and file the complaint or application against the banking company? There is option yes, operational creditors are entitled. No, financial service providers are excluded. Yes, banking companies are covered under this code. No, catering is an excluded service under the code. So thing is, banking companies are considered as the financial service providers. They can go to adjudicating authority and can file, but the thing is, IBC is not applicable for the financial service provider. So in this case, no, financial service providers are excluded. So they cannot initiate the insolvency process against the bank. What is the reason? Financial service provider. Let's see applicability. That is the so examination point of view. This is the exam. One question is given. So based on this question, they can ask any question with regard to the applicability of IBC. So applicability of the IBC, will see any company incorporated under Companies Act, this law will be applicable. Any company, simple. Any other company governed by any special act, that also will be applicable, special act. Any limited liability LLP, this will be applicable. What is applicable? IBC will be applicable. Any other body corporate under any law for time being in force as the CG may notification, if there is a CG notification, applicable. So company, special act, LLP, notification by the government. Next comes personal guarantors to corporate debtors. This IBC will be applicable. Partnership firm, proprietorship also applicable. Individuals other than the person refers to in clause E. These individuals. Other than that, those individuals also will be they will come under IBC. Companies governed by Companies Act, LLP, notified entity, persons, guarantors to CD, who are CD, corporate debtors, partnership firm, proprietors, individuals other than the partner, personal guarantors. What is the meaning of personal guarantors? Will come? Yes, they will come here. So that is one thing. For examination point of view, this is very important. Non-applicability of the code. The code is not applicable to corporates in finance sector. Section 3 subsection 7 of Insolvency and Bankruptcy Code 2016 states that corporate person shall not include any financial service providers. So as per this, so for banking company, IBC will not be applicable. So catering contracts cannot initiate IPC. Insolvency resolution, IR, insolvency resolution process. Thus the code does not cover bank, financial institutions, insurance company. So in exam they will change this to the insurance company. They may ask at that time also, in IBC will not applicable. Asset restructuring company, they may can give financial institution, or they may can give insurance companies, or they may give asset restructuring companies, or they may give mutual fund, collective investment schemes, or pension, collective investment scheme, or pension fund. However, NBFC is engaged in various activities, and hence NBFC is not in facto, ipso facto excluded from the definition of corporate person under section 3 subsection 7 of this insolvency code. NBFC can be corporate debtor. So one more important questions can be asked, they will give NBFC in that case. Yes, for this, because of they are a financial service provider, for that reason no. Who are the financial service provider? Means a person engaged in the business of providing financial service in terms of authorization issued or registration granted by financial sector regulator. However, section 227 of the code, which was notified on 1/5/2008, provided that CG can notify financial service providers for purpose of insolvency and liquidation proceeding, which may be conducted under the insolvency and bankruptcy code in consultation with the appropriate financial sector regulator. So CG can notify, but as of now it is not applicable. Again, this is not applicable for your examination point of view. Till section 60 it will be applicable for exam. So let's move on to question number 2. The timeline of 180 days for corporate insolvency resolution process commences from the date of debt, date of preferring the application, date of admission of application by NCLT, 90 days after the debt is due. So this will be applicable date of admission of application by the NCLT. Ruby Limited filed an application to the NCLT stating that corporate insolvency resolution process against him cannot be completed within 90 days under the fast track insolvency resolution process. Now question comes, what is a fast track resolution process? Fast track corporate insolvency resolution process of a corporate debtor or LLP. This will come under chapter 4 of the part 2 of the code, section 55 to 58 actually. Okay, let me explain. Small company, it may applicable fast track, or a startup company, or unlisted company. First, filing of application to NCLT along with the proof of existence of default with information utility. There should be a proof of default, that is existence of default is there with the information, and such other information, if it is specified, such other information should be provided to NCLT. Fast track, that is a corporate insolvency resolution process, shall be completed within 90 days. So that is why it is called fast track. So from the starting date to end, it should be 90 days. There is a one-time extension, very important, one-time extension of 45 days. There is only one time. You cannot say first time 15 days, then 15 days, so there is only 30 days is there, still 15 is pending. No, you cannot do such thing. If you give one time 15, that's over, only one time. So one time extension of 45 days may be granted by the adjudicating authority, that is the NCLT, on receipt of application by the resolution process professional. The process flow of insolvency resolution process under chapter 2 and the provision related to offences penalties under chapter 7 of the part 2 shall apply in case of fast track. So that is all about the fast track. So in this case, Ruby Limited filed an application to NCLT stating that a corporate insolvency resolution process against him cannot be completed within 90 days. Okay, they are telling within 90 days is not possible under the fast track insolvency resolution. Considering the application and on being satisfied, NCLT ordered to extend the period of such process by 30 days. They can give up to 45 days. In this case, they given 30 days extension. Later again, Ruby Limited initiated an application for further extension of time period of insolvency process by 15 days. So they thought that there is an extension of till 45 days. No, there is a pending of 15 days. So they applied once again for extension. Decide in the given situation whether NCLT can extend timelines by further 15 days. Yes, because the extension of duration in total is not exceeding 45 days. Wrong. Yes, depends of the facts. If it is justified, NCLT may extend the timelines. Wrong. No, extension of the fast track insolvency resolution process shall not granted more than once. Answer is C. Only once, one extension. Next comes question number 4. Whether an operational creditor can assign or legally transfer any operational debt to a financial creditor. Question is, who is operational creditor? See here, creditor. Creditor means any person to whom a debt is owed, includes financial creditor, operational creditor. Okay, that you know. Let's go to operational creditor. Operational creditor means a person to whom an operational debt is owed and includes any person to whom such debt has been legally assigned or transferred. Again, the word operational debt comes, you need to understand what is operational debt. Operational debt means a claim in respect of the provision of goods or provision of services, including the employment, or a debt in respect of the payment of dues arising under any law for the time being in force and payable to the central government, any state government or any local authorities. So let's go to the question what they asked. Whether an operational creditor can assign legally transfer any operational debt to a financial creditor. Yes, however, the transferee shall be considered as an operational creditor to such extent of transfer. Yes, but the transferee shall be credited considered as a financial creditor in relation to such transfer. No, operational creditor cannot assign legal transfer operational debt to a financial creditor. No, wrong. They can transfer. The answer is A. The transferee shall be considered as an operational creditor to such extent of transfer. Fifth question. Dash shall be responsible for carrying out the entire corporate insolvency resolution process and managing the operations of the corporate debtor during the process. Who is responsible? Committee of creditors? No. Adjudicating authority? No. Insolvency professional? No. Resolution professionals? Yes. Resolution professionals are responsible for carrying out the entire corporate insolvency resolution. What about their mentioned word committee of creditors? What is that committee of creditors? Committee of creditors, COC. Let's say there is a default, so there is an appointment of insolvency professional, correct? Then there will be a moratorium period. I will explain what is there later. That is around 180 or plus 90, that is 270 days. Then there is a formation of committee of creditors. What will happen in that? 75% of the creditors approve for the implement of the plan, then they can implement the plan for the resolution. There is a no, this is yes, 75% approved. There is a no approval, then no usage. There is a no improvement, there is a no possibility of resolution, then they will goes into liquidation. Okay, next question. ABC and Company, the tax consultants of X Limited, for which an interim resolution professional, Mr. A, has been appointed under the corporate insolvency resolution process, has refused to furnish information to Mr. A on the grounds of client confidentiality. Are they right? What? ABC and Company. Okay, ABC and Company, they are company. What company? Tax consultant. Okay, consultants. Okay, of X Limited. For which an interim resolution professional, Mr. A, has been appointed. Okay, Mr. A has been appointed for this company under the corporate insolvency resolution process, has refused to furnish information to Mr. A on the grounds of client confidentiality. Oh, they are not giving the information to Mr. A. The reason being they are telling client confidentiality. See, you're doing the resolution process. Does this really matter? Yes, they are right. No, they are not right. No, the code provides power to IRP to access all the information from various parties. Correct. B is correct answer. Partly right. No, they can do only after. No, they can do all the power. They have all the power. Mr. A is not right in even asking for the information. What answer is B? IRP to access all the information. Access all the information. So this is wrong. Next question. Mr. Satya filed a petition for default of non-payment of debt against Mr. X. Okay, let's explain clearly. There is a Mr. Satya. Okay, then there is a Mr. X. File a petition for default of non-payment of debt against Mr. X. Okay, he is a defaulter. So he is a debtor. Who is telling? So he is the petitioner. Petitioner, those who make a complaint. Correct? Basic. Of course, he will become respondent. We'll continue question. The amount in default claimed by the petitioner was rupees 30 lakhs. He tells he has to pay 30 lakhs. Who? Mr. X has to pay 30 lakhs to Mr. Satya. Whose claim? Mr. Satya's claim. Mr. X pleaded before the AA adjudicating authority that the amount of claim was not belonging to the applicant. Oh, he tells who the hell are you? Who are you? He is telling this amount is not belong to you, it is belong to someone else. It is belong to pleaded before the adjudicating authority that the amount of claim was not belonging to the applicant. Mr. Satya asserted that he himself with his son owns rupees 26 lakh to the respondent. Oh, now he tells with my son I own rupees 25 lakhs with son. Though nowhere in the petition he admitted that he himself with his sons owns rupees 26 lakhs to the respondent. It is not mentioned in the petition. Okay. Considering the above facts, in the light of the Insolvency and Bankruptcy Court, state action to be taken by the adjudicating authority. NCLT will admit the application of Mr. Satya as he jointly with his son owned the debt to Mr. X. So, is a valid petitioner? No. How can it will be valid? Is a unknown person because AA will not know the fact. Someone else cannot file application for somebody else. So this is wrong. B. NCLT will admit the application filed by Mr. Satya on behalf of his son. No. Wrong. NCLT will reject the application considering that no default has occurred against Mr. Satya and his stand as a financial creditor is not proved in the petition. So that is the crux of the matter. Is not proved as a financial creditor in the petition. So he cannot go against Mr. X, and he cannot make a application. If he makes application, the application will be rejected. This is the correct answer. NCLT will dismiss the application on the ground of non-clarity as to existence of the dispute. So C will be the more proper answer. Question number, we'll see 7. C, correct. That is given under section 7(5). Moving on to next question. Person who has provided goods or services and the payment for the same is due from the corporate debtor is a operational creditor. Now question is, who is a financial creditor? Financial creditor. Financial creditor means any person to whom a financial debt is owed and includes a person to whom such debt has been legally assigned or transferred. Now question is, what is a financial debt? Financial debt means a debt along with the interest, if any, which is disbursed against the consideration for a time value of money, includes money borrowed against the payment of interest, any amount raised by the acceptance under the acceptance credit facility, any amount raised pursuant to the any note purchase facility or the issue of bonds, notes, debentures, loan stock, the amount of any liability in respect of any lease or hire purchase contract, receivables sold or discounted other than any receivables sold on non-recourse basis, any amount raised under the any other transaction including forward sale or purchase agreement, any amount raised for from an allottee under the real estate project. Expression allottee and real estate project shall have the meanings respectively assigned to them in clause D and Zn of section 2 of real estate. Any derivative transactions, any counter indemnity obligation with respect of a guarantee indemnity bond, documented letter of credit, any the amount of any liability in respect of any guarantee or indemnity of any items referred in clauses A to H. So this is the financial debt. So what is a financial creditor? Any person to whom a financial debt is owed, includes a person to whom such debt has been legally assigned or transferred to. So let's move on to next question. So we finished MCQ. Next comes question number 1, descriptive questions. When will the provisions of the insolvency and liquidation of the corporate person be applicable on corporate person? When will provisions of the insolvency and liquidation of corporate persons be applicable on corporate person? What is the amount? It is more than 1 lakh, right? The provision relating to the insolvency and liquidation of a corporate debtor shall be applicable when the amount of default and the amount of default is 1 lakh rupees or more. 1 lakh rupees or more, but CG can increase the amount, okay, up to 1 crore. We'll see. However, the CG may by notification specify the minimum amount of a default of higher value of which shall not be more than 1 crores. More than 1 crores. It cannot be more than 1 crores. So this is the minimum value can be fixed by the CG. Now 1 lakh rupees. Moving on to next question. What is the insolvency resolution process for a financial creditor? financial creditor. A financial creditor, either itself or along with the other financial creditors, may lodge an application before the AA, that is the NCLT, for initiating corporate insolvency resolution process against a corporate debtor who commits a default in payment of its dues. That you know. The financial creditor shall, along with the application, give evidence in support of the default committed by the corporate debtor. Evidence. He shall also give the name of the interim resolution professional. Okay. Where the adjudicating authority is satisfied that a default has occurred and the application by the financial creditor is complete and there is no disciplinary proceedings pending against the proposed resolution professional, it may admit such application made by financial creditor. Otherwise, the application may be rejected. However, the applicant may rectify the defect within 7 days of the receipt of the notice of the rejection from the adjudicating authority that we seen before. What is the insolvency resolution process for operational creditors? On the occurrence of default, operation creditor first send a demand notice and a copy of invoice to the corporate debtor. The corporate debtor shall, within a period of 10 days of receipt of demand, notify operation that we all dealt initially. You see in fast track also